Did you know that most firms do not have a succession plan in place for their law firms? Failing to have a succession plan in place could result in loss of earnings, potential discipline by the Office of Lawyer Regulation, and undue stress for your colleagues and family members. I'm Christopher Shattuck, the State Bar of Wisconsin's Law Practice Assistance Manager, and today I am joined by Dean Dietrich, shareholder and attorney at Dietrich Vanderwall Law Group SC. In addition to his practice, Dean volunteers and serves on the Professional Ethics Committee and Senior Lawyers Division. Today, we will discuss some important topics on succession planning for lawyers. Dean, thank you for joining us.
Good morning, Chris. How are you doing?
I'm great. Thanks for being here. So why should solo practitioners have a succession plan in place?
It's part of the duties and responsibilities of a lawyer under the rules of professional conduct, particularly for small firms and solo practitioners, as part of their duty of diligence to their clients to ensure that they are able to meet the needs of their clients, even in the event there should be some disaster occurring, in particular to a lawyer's health. So there's an ethical responsibility. Now, lawyers also serve as fiduciaries for their clients. And there's, again, a role in the legal theory of fiduciary duty to ensure they're always protecting the best interests of their clients. The business reason, I think, is more important. And it's certainly something I've thought about and think about regularly. I really owe it to my clients because they put their sure they are taken care of if something would happen to me. Now, sometimes that's just with another lawyer in the firm, being able to be advised about cases, much more aggressive action.
Thank you, Dean. And I'll also just note that solo practitioners do have an ability under their state bar profile to utilize the State Bar of Wisconsin's law practice succession planning registry, where they can name their own successor in their event of death or disability. So outside of the comment to the rule that you mentioned, Chapter 12 of the Supreme Court rules covers a lawyer's death, disability, and medical incapacity. Could you provide an overview of that chapter?
I sure can, Chris. This is Supreme Court Rule Chapter 20, and it's entitled Client Protection. And it really has a number of provisions in the event an attorney is unable to meet the needs of their clients, either due to death or disappearance or medical incapacity. It provides a procedure for a family or another lawyer to go into court and to get the court's approval of that lawyer. The handling's a bad word, so I'll explain it. Handling and processing of the client matters in an instance where a lawyer becomes incapacitated. A lawyer that goes into court to get appointment by the court to handle these matters is not obligated to take over all of the representation. More importantly, the lawyer is obligated to handle the cases, protect the clients, ensure that the cases are going to be handled by the appropriate lawyer that has the background, for example, in the area, protect against any loss of timelines and stuff like that. So it's not that the client that or a lawyer that's asking for the court appointment has to do all the cases, but it's really taking over for handling and making sure the cases are moving forward and the clients are protected.
Thank you, Dean. So what happens if there is no successor in place, or if the successor in place does not opt to use Chapter 12 of the Supreme Court rules? I know that the solo and small firm section produced a solo practitioner's handbook for death and disability. Can you give us an overview of some of those options?
Yeah, certainly, Chris. the options there of the lawyer and the personal representative of the lawyer taking over the business, if you will, of the law practice. Doesn't have to be a lawyer by trade, but it's somebody that has a connection to the family. And again, the responsibility is to ensure that the clients are protected, that all timelines are met, all scheduling is taken care of. So it's the responsibility of the family member personal representative to step in and ensure that things are properly handled. I've seen cases negotiate the purchase of the practice by another lawyer. Sometimes the personal representative is going to go in and handle kind of the business end of the law practice, ensuring that timelines are met and everything is handled, cases are passed on. But it's really important for the lawyer, particularly the sole practitioner, but really any practitioner, to make sure they have systems in place so that someone can come in and easily determine what cases are pending, what timelines exist. All of that is not only just litigation management, but all practice management, transactions as well, that type of thing.
So if a law firm was being proactive and they wanted to sell their law firm, what restrictions do the attorneys have on practicing after the sale is concluded?
The Wisconsin Supreme Court Rule 20:1.17 addresses the sale of a law practice. The first one that exists, Chris, and you mentioned, is if a law firm or a lawyer is selling their practice, they may not engage in the practice of law in that area after the sale of the practice. Now, when I use the words in that area, I mean the practical area. So in other words, the lawyer that's selling the practice, and sometimes you're selling a part of a practice, although I don't see that very often, but maybe like my case, I do labor negotiations. Maybe I would sell the labor negotiations part of my practice. I must discontinue engaging in that type of practice of law. Now, I see a variety of situations where lawyers do have success in selling their practice. Obviously, a lot of it is goodwill and client relationships. But in every case, the client has the right to determine whether or not they are going to continue representation with the purchaser of the practice, or whether they're going to go to another law firm. So it's always the opportunity of the client to decide whether or not they will continue representation with that law firm.
Thank you, Dean. And what I see sometimes too is that lawyers are unaware of this rule and may sell their practice and then look to potentially practicing again in the future and not realize the prohibition of practice rule. And I also know that some firms that are aware of this rule are very cognizant of this rule. So instead of selling their law firm under 20:1.17, they will instead opt to do a merger with the law firm and then receive some sort of compensation benefits out of that to make sure that there are no restrictions on practice. But again, lawyers need to realize that that although they are prohibited in the sale of a practice from practicing in that geographical area, if it's a merger, the law firm doesn't have a mechanism under the other Supreme Court rules to prohibit that attorney from practicing in the area again. So there needs to be a lot of trust on both sides and an understanding of how the Supreme Court rules work out. So moving on to the last point, Dean, when you know or plan on—
That's right, Chris.
Thank you. And so when you know or plan on transitioning from your firm, what does 20:1.4 require as it relates to letting your client know of your anticipated transition?
Yes, 20:1.4, as you described, is the communication rule. And there's a obligation to sell their practice or leave their practice. We often call it transitioning their practice, to communicate with clients regarding the representation and communicate exactly what the facts and circumstances are of the lawyer leaving the practice. There again, the client has the opportunity to decide how they're going to proceed with retaining other counsel. Lawyers who are transitioning out of the practice certainly sometimes will help find a lawyer to handle the matter. You have to be very careful that if the lawyer that's leaving the practice is expecting some sort of continued compensation from the lawyer that now gets the file, the two lawyers may be jointly representing that client. So the lawyer leaving the practice may still have both ethical and fiduciary duties to that client, even though the described intent was for the lawyer to be transitioning out of the practice.
Thank you, Dean. So it's fair to say that if a lawyer knows that they're going to be transitioning from their practice, that's a point that they're going to want to bring up with their clients to let them know how that may impact their representation and also what the succession of the representation would be.
Right, right. And it's absolutely critical that there be a communication. I've worked with different lawyers in drafting letters to clients, and it doesn't have to be a treatise, but it's got to make it very clear what the timeline is, what the expectations are, what the opportunities for the client are in moving forward.
Excellent, Dean. Well, I want to thank you for joining us today. We will include hyperlinks to a lot of the different resources that we discussed and covered, including the Supreme Court rules, the Death and Disability Handbook, and also some helpful articles that we've written on these subjects in the past. And of course, if you have any questions, you can feel free to contact us. We'd be happy to help you out. Dean, thanks again for joining us today.
Thank you, Chris. Have a good day.
You too.